Mr. Speaker.
I call the Honourable Minister Chris Finlayson.
I will choose my words very carefully because I believe that great care is needed in debating this issue because of the fact that proceedings are currently before the High Court. But there was a very interesting issue of principle that was raised by the Deputy Leader of the Opposition, and that concerns the meaning of Section 8.3 about the performance of the Bureau's functions being subject to the control of the Minister, and there's no debate in this instance, it's the Prime Minister. I always recall many years ago when David Lange first became the Prime Minister and Minister in charge of the SIS, there was a quip of him on television when he was visited by the Director of the SIS, and he said, "Bring me all the files," in a typical David Lange joking way, and the Director said, "Well, it's not like that," and it's not like that. That control of the Bureau does not mean operational control over particular matters, and I'd venture to suggest that if ever we got to a situation where the Minister in charge of the SIS or the Minister in charge of GCSB was exercising operational control over the operations of the agency, particular operations of the agency would be a very dangerous and improper state of affairs. And so it is that I, as Attorney General, exercise control over Crown law. Indeed, I've just been hunting for the particular reference, but I know it's set out in the Cabinet Manual. But it would be quite improper and unconstitutional of me as Attorney General to exercise control over particular cases. And so during the allegations over the intervention by the Solicitor General in the case involving the cameraman Mr. Ambrose, I in fact had nothing to do with it. It would have been quite improper of me to have had anything to do with it. The Attorney General was named as the nominal defendant in that proceeding because there was, to quote the statement of claim, no proper contradictor, and that is why the Attorney General was named, but that did not give me licence to get involved in the control and operation of that particular case, and that is the case here. Mr. Speaker, it's been the government's announced position on the use of the capability of this particular agency that in relation to the two of the persons whose communications were required, that the activity was contrary to its governing legislation. But given the confused at times contribution by Mr. Robertson, I do think that it's necessary to explain something of the background of this case and how we get to where we are, and in doing so I emphasise the need for care in talking about this particular matter. The background starts in the United States because Mr. .com and his associates have been indicted in Virginia on charges related to the theft of intellectual property on an industrial scale. It was necessary for the carrying out of New Zealand's obligations under its extradition treaty with the United States that arrest warrants issued by a New Zealand court on behalf of the United States were executed in a manner that properly and effectively assisted the US in relation to an operation that involved 8 or 9 different countries. In those circumstances, there can be no surprise in the fact of the police request for assistance in tracking persons who were subject to warrants, and in relation to persons who are not New Zealand citizens or permanent residents, the agency, the GCSB, is entitled to assist. But I emphasise, Mr. Speaker, that there can never be an acceptance by the government or the public of the unlawful use of state power, particularly in relation to the acquisition of communications, and that must be emphasised. The circumstances of the misuse of the relevant power and the question of what follows from that event is now an issue which is squarely before the High Court. The court will deal with that issue, as it intimated to Mr. Dotcom's counsel, in the fullness of time. But I emphasise that New Zealand is part of the wider international community, the lifeblood of which is the acceptance of international obligations, in particular those directed to the detection and suppression of international crime. And I said that Mr. Robertson, in his analysis, was talking about extradition orders and was explaining the procedure, but I don't think very clearly. I think it needs to be emphasised that there are two proceedings here, and the first is the request for extradition. That is an act of the executive, which is based on obligations undertaken by, in this case, the United States and New Zealand. Every extradition request will involve the consideration at some point in the process of two competing public interest principles: the interest of comity on the one hand and the liberty of the individual on the other. In New Zealand, as we all know, extradition's covered by the Extradition Act 1999. It's administered by the Ministry of Justice, but it does, as Mr. Robertson observed, involve a number of agencies at any one time. The Ministry of Foreign Affairs and Trade, for example, receives and transmits requests for extradition. The Ministry of Justice will assess requests and appearing in New Zealand courts on extradition matters, or instructing other counsel to appear, in this case, Crown Law. So both countries, sir, have a bilateral extradition treaty that forms the basis of their requests to each other. And it's important to understand here that extradition proceeds on the basis of a record of the case. That is, that the US provides a summary of the evidence supporting extradition and any other relevant materials. And then what the New Zealand court has to do is approach the record on the assumption that it's a fair and an accurate summary of the evidence against the defendants. It is not the role of the courts in New Zealand to try the person for the offence alleged. Ultimately, if the extradition takes place, that will be the responsibility of the Federal District Court in Virginia. But what the New Zealand court has to do is assure itself that there's a qualifying offence on which the person may be surrendered to the other country for trial, and that there's sufficient evidence. And it's also important to understand, which explains the detailed nature of extradition, that once that preliminary review has taken place, the judge considers the evidence, determines whether a person's eligible for surrender. The Minister of Justice will decide whether to surrender the person, and if that happens, then there's an opportunity by the person concerned to seek judicial review in the High Court of both the judge's decision to recommend that and the minister's decision to surrender. So it's very important that we understand that extradition is one particular process, and then mutual assistance is another. That's an entirely different form of international cooperation, and it's that one that concerns the provision of evidence or information to assist the foreign country with a criminal investigation or prosecution. And if New Zealand responds positively to the other country's requests, then they in turn will assist New Zealand authorities when we make requests overseas, and that happens on a regular basis. And members may have seen that recently there was a request in Australia which was turned down by the federal court there for various reasons. So we're all partners in dealing with alleged and actual transnational crime, and conventions require New Zealand to provide mutual assistance as part of a global approach to crime. So it's important not to muddle up the two processes. There's extradition on the one hand, mutual assistance on the other, and the other thing that it's important to understand is whether Mr. Dotcom and his associates are rightly or wrongly charged is ultimately a matter for the courts in the United States. But it's also important to understand, as I said earlier in this speech, that it's obvious that it's open to Mr. Dotcom and his associates to challenge New Zealand's actions in courts of law. There are open courts and proper remedies that are available for any transgressions of the law, and presumably these are the sorts of things that are going to happen over the months to come. I've set out those matters in some considerable detail because I do think sometimes in public discussion on this matter there's been a conflation of what extradition's about and mutual assistance, but I emphasise that these matters are now fairly and squarely before the court, particularly as a result of a direction made by the Chief High Court Judge yesterday, and that is why it behoves all of us to deal with this matter with some sensitivity because of the sub judice rule, which is not a mere rule but actually raises issues of great constitutional importance about the interrelationship, or the relationship, I should say, between the executive and on the one hand and the judiciary, and also Parliament and the judiciary. So, Mr. Speaker, they are the issues that have arisen in this matter. There is a question as to what constitutes control of the Minister in this instance, and I have said that there is a world of difference, and I say this to Mr. Twyford because he does raise an important matter. There is a very important point of distinction between exercising control over the agency, which is what I believe the Prime Minister has done at all times in this case, and becoming involved and exercising control over particular operations. And I say to him, I say to Mr. Twyford that to get involved in the detail of particular operations just as it is improper, just as it would be quite improper for me to become involved in the particular operation of particular cases, and I'm not willfully misunderstanding anything. These are matters of great constitutional importance, and when one is dealing with the intelligence agencies, or in my case one is dealing with Crown law, one has to be very, very careful about the extent to which a minister exercising control gets down into the detail. And the line that he's suggesting is a very, very dangerous line.
I call the honourable member, Dr. Russell Norman.
Thank you, Mr. Speaker. I rise to speak on